Welcome to Conflict to Clarity in Family Matters with Rahul Kishore.
Hello and welcome back to Conflict to Clarity in Family Matters with Maryland divorce attorney Rahul Kishore. My name is Kevin Rosenquist, and in this episode, we're tackling a tough but very common issue: what to do when your spouse is stalling, stonewalling, or just refusing to participate in the divorce process. If you're dealing with a spouse who won't cooperate, this conversation will help you understand your rights as well as the next steps. Rahul, good to have you here.
Good afternoon. How are you doing today?
I'm doing great. Excited to chat with you. In your experience, you've been doing this for a while now. What are some of the common ways that people experience a lack of cooperation from their spouse during a divorce?
Well, what we see is that there are some people who don't want to get divorced, and they don't want to, they stonewall the whole process. And what they do is they don't respond to any pleadings, which at certain points, what we could do is we explain to our clients that if they don't respond, as long as we serve them, what that means is we have to serve the paperwork for the original complaint that we filed for you. And if they do not respond within the number of days that you're allowed, if you're living within the state that we file, which is in Maryland, you have to respond within 30 days. And if you're an out-of-state resident, they have to respond within 60 days. And if you're out of the country, you have to file within 90 days. And if they don't respond within that time period, we would ask the court to file a default judgment. That's the first thing we tell our clients. But if we do get past where they do file the response, then what we do is let's say they don't respond to basic requests for discovery. We can file what we call motions to compel. We can also file subpoenas to financial institutions to get records in a divorce, in a custody case, to their pediatricians. We can get their investment accounts. We can get retirement accounts. I have a case right now where we're trying to get information on stock options for a gentleman. So we will be subpoenaing their employer to get the information. So those are the basic tactics. But in addition, we can also take a deposition of the parties or any other individuals that we may need to do to get information if somebody's stonewalling us.
Wow. Well, you could actually go to the employer for that information. Does it get to that point often?
Yes, it does. Especially if you have I have a CEO right now who is refusing to provide the information, and he feels that the marriage was a very short marriage, and that that there's no marital property. But the laws are very clear that there is marital property. You've been married 3 years, and if you gained some stock options, we need the information. And he's stonewalling us, so that does happen, and it's an interesting world that we live in.
Isn't that the understatement of the year?
Yeah, that's true on many fronts. Yes.
So when it comes to separation agreements, if someone's spouse won't sign it, can they still get a divorce? Or does that have to be signed?
Oh, no. Under Maryland law, there's 3 ways you can get divorced. One is the best and quickest and most efficient way, which is we get a marital settlement agreement signed, which addresses all the investment accounts, retirement accounts, to vehicles, the marital home, and including the custody and child support issues that come involved in a divorce, if you have children, obviously. If you do get that agreement signed, we would file, which is one of the 3 ways you can file for a divorce in Maryland, which is a mutual consent. And that's when you need the separation agreement that you're asking me about. But if you can't get to that situation and you get an agreement signed to file based on mutual consent, what we do is we file the other 2 grounds in Maryland, which is the laws just changed, by the way, in October of 2023. The other 2 grounds that we can do in Maryland is what we call irreconcilable differences. And this other way is we can file what we call 6-month separation. And since this new law passed, Irreconcilable differences is exactly what it sounds like. You can state that there's many, many differences, from finances to how to upbring your children to how to deal with, day-to-day life. And you can, or from, abuse to any issues that you think that create irreconcilable differences. But the other ground, which is the other third ground you have, which is called 6 month separation. What's happened in Maryland is that now you're allowed to, prior to this new law, you had to be separated, first of all, for 1 year. Now they've reduced the time period to 6 months. And what's also interesting is that the 6 month period can also be living under the same roof, but you say you're physically separated within the same abode. And that you can also do now in Maryland, which is pretty exciting for us. And the one other thing I'd like to also emphasize to you is that Maryland is a no fault state now, meaning you can't file a divorce based on fault. You can only base it on those three grounds that I brought up, which is the mutual consent based on the separation agreement, or number two, based on irreconcilable differences, or number three, the 6 month separation.
Okay, so I'm assuming that mediation is used a lot in these scenarios. Does it get to the point where you don't even bother with mediation and go directly to court if you can't get if you can't get the other party to respond?
Well, let me emphasize one thing. I'm a big proponent of mediation, and I am a mediator through the court system here, and licensed and trained to do mediation. And if you look at my website, we are huge proponents of mediation. But the only times we do not encourage mediation is if you have two parties. One party is completely clueless on the finances and doesn't have enough knowledge, and believes the other party will not be straightforward and transparent in providing the documentation. Because mediation is a process which involves both parties to come, be honest and upfront, and then negotiate terms based on the information. But if you do not have that information, we do not want to sit down with somebody who's not giving it or being transparent with the information. Like, for instance, if a husband has 6 different bank accounts that you don't know about, well, if I'm representing the wife, I'm not going to do that without going through the discovery process, which involves filing a lawsuit and going through what we call the formal discovery process. Now, the other times we don't encourage mediation is if there is a power struggle. And what I mean by that is we do not encourage mediation if there's been a history of physical abuse, uh, mental abuse, and those kind of things, where we don't think it's valuable to sit down in a situation, be able to mediate in the proper way. We do not encourage mediation in those situations as well.
Okay, yeah, that makes sense. That definitely makes sense. That if there's just someone has no idea what's going on financially, or if there's been abuse, that completely makes sense to me. So what if the spouse, if the spouse of your client just doesn't respond at all to the divorce filing?
Right. Well, that's exactly what I was trying to tell you a little while ago. I mentioned to you that we wait for the 30 to 60 to 90-day period, depending on if it's an in-state client, out-of-state client, or out of country. You get those specific days to respond. If I file a complaint and I serve somebody, you have to be able to properly serve the party and give them notice that they have the paperwork. If you follow the laws on that, then if they don't respond within the 30, 60, 90-day period, whichever time period applies to the defendant, which is the other party, then what we would do is we would file a default judgment. The court would grant us the default because the parties didn't respond. And then we would still proceed to get the divorce. Even though you get a default, the court will schedule in a divorce hearing, and you would get the final hearing and get divorced. And if there's custody involved, we would just go to this final hearing where the party, we were granted a default. And what a default basically means is that the other party didn't respond, and now they cannot defend themselves in the case. And we proceed to go forward with our evidence and seek what we're seeking, and the court normally grants that to us.
If someone is dragging their feet, stonewalling, doing all the stuff we've been talking about, are there dangers to waiting too long to react to that? Is it something that's you need to get on right away?
Yeah, of course. If they're stonewalling, if they don't want to sit down and negotiate a marital settlement agreement, they don't want to go to mediation, the first thing we tell our client is you need to file immediately. Number one, the reason is the more you wait, and if there is a problem at home and you know that there's a distance, if first of all, one party starts to move assets and finances and tries to deplete the marital assets, that could be a major issue, and that could affect your overall ability to get money, what we call the marital property, in the end of the case. And that's one thing. The second reason is the more you drag things out, the more it becomes an issue with regard to custody, meaning if there's a problem and you need the assistance of the court to maybe in certain situations have what we call supervised visitations, you're not going to get in front of the court and get a court order if you delay the process. And the more you delay, it's not in the best interest of your children to do that. And it affects them emotionally and mentally for a long time in their life. And I read a lot of books about that, and I can tell you that we emphasize what we call the best interest of the child. And that's why you would want to go ahead and file for divorce and get the courts involved. We can get custody evaluators involved. Custody mediation is also ordered by the court in a lot of situations. So there's a lot of things you can do during that process to help you.
Obviously, divorce is a very emotional situation, 9.9 times out of 10, and emotions run high and all of that. How do you help your clients sort of balance that emotion with practicality, especially when their spouse is not playing fair, is stonewalling, is doing all these things? It's got to be even more frustrating to them. What strategies do you take in those situations?
I honestly, listen, I've had cases where the case seems up front that the other side is stonewalling, they're difficult. The strategy we use is if a lot of this also depends on what type of attorney we're dealing with on the other side, and how amenable they are to the process of mediation and being transparent. If we have a situation where they're not transparent, what we do is we help our client understand that we're going to hold their hand. We're going to try to mediate, and we're going to try to get this resolved as soon as possible. If we can do that with the assistance of transparency and the assistance of other counsel, providing the information we need, and we provide them the information they need, and to sit down and mediate. If that's not possible, we're going to use all the tactics that I've discussed, which is we're going to file, we're going to serve you, we're going to issue subpoenas if we need to, we're going to propound discovery upon you, which is interrogatories, which are questions. We're going to propound a list of documents you have to produce. We're going to take a deposition of you if we need to do that. And we're going to tell our client that this is the avenue that we need to go so that we get you to the end goal of being fair and doing what we need to do to give you and if you have children, put their best interest in the forefront, and get the goal of getting a custody arrangement and getting you child support that you are able to get if you have custody of the kids, and basically be your advocate. And that's what we here at Rahul Kishore basically try to do, is be your best advocate and put our best step forward to get you to where you want to get to.
In your experience, when these things start out where one spouse is just being completely uncooperative, not getting back to people, doing all the things that we talked about today, do they typically still reach a settlement, or do these cases typically end up in court?
Like I said, the more you push somebody, if they're not being cooperative, if I subpoena if I issue 7 subpoenas to 7 different bank accounts and they realize that I know the bank accounts and I've gotten the information and I've subpoenaed them and they realize that, I'm going down a hole that I don't want to go down, there has been many, many situations where we've gone down the process, we've gone a couple months, we've started getting information, and then all of a sudden, the other side wants to sit down and try to negotiate a fair and reasonable settlement. And that does happen. And settlements happen a lot of the time. We are, again, proponents of not going through a litigation process. Nobody wants to do that. It's very tough. It's very emotional. It's very stressful for anybody. And we try to get to a settlement where we think it's fair. And I think most people, we do get there, 75, 80% of the time. So that's what over the last 30 years of practicing law in this arena, I've been able to do that for my clients, and they've been very happy.
Oh, good. That's great to hear. All right. Well, if your spouse is refusing to cooperate, don't assume you're stuck. You still have legal options, and the court can help you move forward. To get clear, honest guidance about your next steps, visit maryland-lawoffice.com and schedule a consultation with Rahul Kishore. And be sure to subscribe, and review our videos here. We love having you be here, and we got lots more great information coming your way. Rahul, great chatting with you. Thanks so much for all the insight.
Thank you for your time today.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.